What's up, everybody? Welcome back into another episode of The Lawyer You Know. I'm really excited about this one. We've got Michael Easter, who is the expert that was supposed to tell us just how bad this law enforcement investigation was done in the Karen Reed case, but we never got to hear from him. Almost every juror I've heard their interview has mentioned the police investigation, the issues with that investigation, and so many of them that think Karen Reed is either innocent or that no collision occurred, which would mean she didn't do it, still want justice for John O'Keefe. They want the real people to be found. And this guy's background and experience can let us know how they handle difficult cases in the FBI at a federal level, how these investigations work, how they look at it, what's normal, what's not, which this case, of course, is anything but. I'm really excited about this one. Everybody hit the like button and let's get to it. All right, Mike, welcome to the show, man. Thanks for coming on.
Yeah, thanks for having me.
So to start out, because we didn't get to dig in too much about your background and expertise coming into the trial, we knew generally what it was about. I've used experts like you in cases, and we've also covered some cases, mostly all here in Florida now that I'm kind of racking my brain on it. So maybe it is really different around the country. But tell us a little bit about your background, your experience, and when you're called as an expert, why do they pick you?
Yeah, well, first, my background after graduating from college, I was an officer in the United States Marine Corps. And during that time, yeah, thank you. During that time, I had some interaction with other government agencies, and one of those was the FBI, and I really found what they were doing interesting. And I was later recruited out of the unit that I was assigned, and I applied to the FBI. But if anybody's ever applied to the FBI or any government position, it takes forever. And my wife was pregnant at the time, and so I was like, I need a job and I need one quick. And so I spent a while as a law enforcement officer where I live now, and finally got a call almost 2 years later to join the FBI, and I did. And I spent a little over 20 years with the FBI. And if I kind of look at and describe my career in two parts. The first part was for the first decade, I spent a majority of my time working violent crimes, and I was assigned to a gang and narcotics task force in Southern California that we specifically dealt with everything you could think of related to violent crime and narcotics. I was the lead case agent on some very big RICO type cases where we took down major organizations, and was the lead case agent on several undercover operations that lasted a significant period of time, where we would deploy some of the most sophisticated investigative techniques the FBI uses. Um, and during that time, I really learned what it meant to be a good investigator. How do you put a case together that not only to investigate alongside the criminal enterprise, but how do we collect evidence along the way so that it makes it to court and tells the story ultimately at the end? How do we manage this case in a proper, maybe use some of Yuri's term, with integrity and honor, so that when it gets to court, no one's looking at you sideways of like, what in the world were you doing? And I even think a lot of my experience came from dealing with U.S. attorneys. The Bureau has a maybe not quite the same as local law enforcement. The FBI, as the investigation's maturing or and looking at something, we interact pretty early with the U.S. Attorney's Office to make sure it's an investigation or type of crime that they would be prosecuting at the time, whether it's in the priorities. And then we really look at what are some techniques that we want to use and what are some effective strategies for them to get to prosecution. So we really have a very early relationship. We're oftentimes in law enforcement, local law enforcement, they're investigating a crime that took place, collecting evidence, and then presenting their case. And it's not always, I wouldn't say ever, but not always where they get to go back to it. So that's what I did for the first 10 years. And then the second 10 years, this next decade, because of my prior military experience in signals intelligence, I was selected to, and let me add to that, during my time as an investigator, I was deploying some techniques, investigative techniques using cell phone signals and other location records in my own personal cases. And the FBI headquarters, I remember, called me one day and they said, "Hey, somebody said you're out there doing these things. Who told you could do that? And how are you doing it?" And I said, "Well, we did these things in the military." and I'm doing them now here because we can deploy them through a search warrant. And that really sort of blossomed into my next decade, where I spent as a national asset for the FBI, meaning nothing super special, but I served the entire country and sometimes overseas with the analysis of historical cell phone records, location-based records, and other geolocation type events, um, for cases all over the country. And maybe just put a pause on all that, that's really was my expertise as I retired. I was an instructor for the FBI on this. I created the curriculum, or was part of the team that created the curriculum for that. That not only taught FBI agents, but agents and investigators across the country and overseas. And so I've deployed as a cast asset to almost every major event you've seen in the news, and either I deployed or I assisted remotely. So, and then maybe my last part would be is because of my testimony, I've testified well over 200 times in trials, both state and federal, is that I then became the FBI's in-house expert witness instructor, and I taught that with a couple other agents that also had an enormous amount of experience, and that I think very highly of. So maybe I'll put a pause there and quit maybe trying to brag about myself so much, and,
No,
let you ask some questions.
that helps us kind of understand what you would bring to the table in a case like this. So when you say you testified over 200 times, have any of those been as the type of expert you were being hired to basically look at an investigation and talk about what you should do, what you shouldn't do, and where they screwed up?
No, not in terms of a review of someone else's case. And I think maybe just put some perspective to that is I retired in January 31st of this year. So I've only been retired for a few months. I have looked at several cases since then, to my surprise, and I think I've mentioned it previously in another conversation, is I didn't know that was such a need from defense. I was really, in fact, I get more calls about that now than I do about being an expert witness for cell phone records, if I'm honest. But I maybe add some perspective to that, Peter, is you have to remember that I spent over in a decade and then another decade as an investigator. And so in my experience of testifying in my own cases, big racketeering cases, and even just robberies, Hobbs Act type cases, kidnappings, extortions, I'm explaining to them how a proper case should go through my own investigation, right? So I am explaining from the government side what a proper investigation looked like, and the steps that we would take to provide an honorable and an integrity in our investigation. So yeah, I think now the difference is it's interesting looking at them from the other perspective, and I've said it before, is I've worked at some now that I'm like, nice job, really, congratulations. I really admire the work you did. And then I tell the prosecutor or the defense attorney, they did a good job, and this is going to be a tough battle for your client.
Yeah, and I'm sure when you were on the stand testifying for the government as an FBI agent, plenty of defense attorneys tried to attack the way you did the investigation. So it's not
Right.
like you never heard those questions. How did you deal with that as law enforcement at the time when it was your investigation they were trying to attack?
Right, and I would totally agree with that. That's a common theme, and I always kind of present it to the students as the things you didn't do. And it is a theme in this case enormously, right? The defense would have used against the witnesses for the Commonwealth. I always think it's best to get out on direct the nature of your investigation, the things you did, and the things you didn't do. Let's highlight why. Well, Mr. Easter or Agent Easter, why didn't you use a confidential informant? Well, we didn't use a confidential informant because one was not available to us in this case, or there could be other legal reasons we're not using a confidential informant against this person, and or the person that we may use as a confidential informant is too equal to the person we're investigating. And we don't like to, your dad probably has some good conversations about this, but the Bureau doesn't like taking equal parties and burying them against each other, and especially a party above and going like a subordinate, getting them to collect information. Because then it's sort of, defense always likes to then bring in the entrapment defense. Well, this person was obligated to do these things because the person is their boss, right?
Yeah.
So I don't know if that answered your question, Peter. Maybe was I being
No.
evasive?
That answers it. And basically what you said is, as long as you have a why to what you did and what you didn't do, and that
Right.
why is proper under the procedures and protocols that you have, and that why is logical, then I think that's a good explanation. And you should expect that as a law
Right.
enforcement agent or officer when you are handling very serious cases like the Karen Reed case. So it shouldn't
Right.
be really offensive or surprising to law enforcement if that is an angle that defense attorneys take. And frankly, talk a little bit about how you, every time you investigate a case, you know the protocols and procedures. If you're going to break them, you know you're breaking them. So if you're going to break them or do
Right.
something different, there's a reason for it, right? So it's not like anybody forces you to do it the wrong way as an officer. So just talk a little bit about how you guys, how are you trained? How do you know what the protocols and procedures are? And should it ever be a surprise if something doesn't go according to those protocols and procedures?
Yeah, that's a really good question, and the answer is yes. Not only when I was a law enforcement officer, but a federal agent. You're trained on policies and procedures. It is the whole point of the academy. One, to collect evidence consistent with best legal practices, and the reason for that is you don't want to violate somebody's rights. Clearly, you can't conduct search warrants in certain instances, but to also know where. Let me maybe say this. In the academies, it is by the book. It is policy, policy, policy. You don't sort of skirt the lines of policy. I will tell you in the real world, and once you go on to be an investigator, you have a mentor. The FBI has a 2-year training or where you're considered a probationary agent. And so you'd be assigned to a senior agent that says, yes, this is the policy, but we can also do these things. They're not necessarily adverse to policy and they're not illegal. They're just sort of right there in the, I don't want to say the gray area, but right in the sweet spot. And there's times, especially, I think in this case, well, let me say this. There's big cases where you really need to um, be right at the line and conservative, and that's because of the scrutiny. Let's say maybe we're looking at a public official, something that's going to get a lot of attention. And then there's instances where I would put an officer down or an officer that's been killed, in such as this case. Everybody knows we're going to go to the line and straddle that line as much as possible without doing anything to violate people's rights. But we are going to take some of the most aggressive stances we can because all of us want, and I'm not saying we don't take aggressive before or we investigate things less. Don't take that as a perspective. But you know, Peter, that when it's one of us, there's this just sort of raw response of we're going to get these people and we're going to go right to what we're allowed to do but not over. And the reason you don't want to go over is then you call into question the legitimacy of your investigation and you open yourself up to yourself personally up to attack and liability. And so that's where I always think there always needs to be a good lead case agent or a good supervisor or command staff that is checking in. Where are we at? How are we progressing? And as we have those team meetings of what's next and we strategize, they need to be the voice of reason. Hey guys, take it easy. We're not going there. Stay here. Stay within the guidelines that we've been given. Remember, we are going to be critiqued on this from, well, we see it here from day to night. And then we would also have those conversations with the U.S. Attorney's Office. And if there's any organization that's risk averse, it's the U.S. Attorney's Office.
That's why they win so much and they file so few cases, right? Because they really
Right.
are conservative. And you hit it on the head from my perspective as not in the FBI agency or in the law enforcement officer or whatever. Like it's a top down problem. You don't go in wanting to break protocol and procedure, but when they're like, we got to get this guy and this is how we do it.
Right.
You do it my way. This is the real world now. You're not in the academy
Right.
anymore. And that happens a lot more than people might think. And I think that probably had something to do with the officers in this case. They didn't start out like this, but they ended
Right.
up here. And we all saw the investigation in the Karen Reed case, and it doesn't take an expert to see that it was a shoddy job or not a normal investigation. So I'll just start out asking you a couple things. You ever seen evidence gathered in red Solo cups before?
Never.
Ever seen them stored in stop and shop bags?
No, I this is my first.
Ever seen the lack of chain of custody for important pieces of evidence to this level that you saw in this case?
No. And when you say lack, I mean, it was almost the concept was foreign to Yuri when he was asked about it. Right. I
Absolutely.
mean, you remember that he seemed bewildered by the concept. A chain of custody. Why would I do that? I said what I did.
Yeah.
It's
Why
like,
do I need to confirm that?
what you mean? Why would you write it down that you did something?
Yeah. It's double
Because it
work.
has to go to. I know this is sort of a diversion from your question, but Peter, think about that for a sec. Is that was I kind of think of it as a cultural thing, which I think hits to your point. Is that their culture was that well. if I say it happened, then it happened. And I don't know if you remember him saying that on the stand. He says, "Well, show me something that a trooper wrote down, and I'll believe it as gospel." I think he said something almost to that effect.
Absolutely.
That's alarming to me. That's a culture that then believes that whatever a trooper says is always the truth. And I'm not trying to say that they're lying. It's just that we don't have that courtesy anymore. That privilege has been taken from us. And for some reason, for some obvious reasons. And now it's why we wear body cameras. It's why we take copious notes and record our interviews, right? Is because we have to be able to authenticate our final statements in that report. And I always think at the end of the day, those things protect the investigator.
I was going to say the same thing. They don't understand that this is all for their benefit. Like,
Right,
how many times did witnesses that are supposed to be friendly to them say, "That's not what I said. That report is wrong. What he wrote." And if you
right,
have the body cam and you recorded the interview, then there's no argument. There's no this guy's
right.
doing a bad job or lying in his reports, or those issues disappear and they protect you as the officer.
And you're so backstopped. You don't have to like try to remember on the stand what you did. Instead, you go,
Mhm.
"Well, I know what I did because I wrote it down in a report. I have a chain of custody. I collected it at 12:02 a.m. I put it in a brown paper bag, evidence bag, and I marked it and sealed it. And then I transported it from 12:43 to 12:47 back to the PD. I booked it at the PD, and that I wrote a report of the barcodes that were booked. Like it can be that simple, right? I would also add in there, you might want to photograph some evidence as you collect it. But I think you brought up a really good point, which I really thought brings to what you just said is that then you don't have witnesses saying that that's not what they told you. And if you think back to Alan Jackson's cross, his first question of Jennifer McCabe was the theme, your prior statements. And remember, he got her to, although she
Mhm.
was not super helpful at the beginning, is to say, didn't you previously tell Trooper Proctor that you saw the car at 12:45 and you sent a text that said hello? And she's like, well, I didn't. And then he kind of goes on to the question. She's like, my, I didn't. She reads it to her and she's like, I didn't say that. And it's like, oh, so either you're lying or Trooper Proctor's lying. And Trooper Proctor, the way you combat that now as an investigator is we could play the recording. I have the recording and we could listen to it for ourselves and we can hear what she said.
I don't know how many times I've taken a deposition and an officer has said, especially if it's somebody with a smaller part of the case, they're like, "I don't know, it'll all be in my report. Whatever I know is in my report." And it's because they
Yeah,
took thorough notes. There's a video or pictures of everything they did. And they are basically just sitting there as a placeholder and they don't know anything or remember anything because it's all in their report. And that's how they do it. And they
right,
do it right. As opposed to this
right,
case, which, like everything Buchanan and Proctor in the first trial testified to, is all just on a trust me basis because
right,
there's no chain of custody. The reports are wrong. The notes are wrong. The dates are wrong. The address of the house is wrong. They had to correct everything 50 different times. I mean, just as an outsider that's not an expert on this looking at it, it boggled my mind. What caught your eye? And I'm going to assume, because I didn't necessarily know you were such a cell phone expert, but I'm going to assume it was more than that in this case. It wasn't just because there was a lot of cell phone data and evidence, but was it the investigation in its entirety that you were brought on to take a look at?
right. Yeah. I really liked what you said there. I maybe just make a comment on it. Is I really try to help students when I teach it. Is when you're not an expert witness is slightly different, but you still need to know your report clearly.
Mhm.
Is when you're a fact witness or an eyewitness, you're a conduit for what you did during the investigation. You're a conduit for it, and that doesn't mean you have to have everything committed to memory. It's the reason we write reports. It's the reason we take photographs. It's the reason we create logs, and it's the reason we record things, right? It's so that you don't have to, these guys, I don't know about them, I'll speak for myself, but you'll be working dozens and dozens of cases across time, and by the time the thing goes to trial, it could be years. And so why would you want to rely on your memory for those things? That's why you document those events so that you don't have to rely on your memory. um, to your other question is yes, my natural expertise is in historical cell phone records and other geolocation records related to mobile devices, right? But I think in that expertise that I provide people, I'm always given their case in a sense. Mike, look at our case. Help us understand how the records fit into this, into our case in chief. And so I usually spend a lot of time reviewing affidavits, police reports. and understanding where does the cell phone evidence fit into corroborate witness statements, corroborate CCTV, and where does it deviate? And if it deviates, why is it deviating? Is it deviating because the witness account was wrong? Maybe there's just a typo in the report. Or oftentimes I usually uncover, hey, that video you have, are you sure that's the right time? Let's go back and normalize the time for the video that you collected. So um, that I would say then, what did I see most? I think is your real question. I've sort of did
Yeah,
the
like
Yuri
when you
on.
looked at it, were you mostly focused just on cell phone, or did you take a look and
Initially,
really give an opinion on everything?
that was the initial request, but it quickly blossomed into Mike. You got to look at the whole case because what I did is I asked questions like I would if I to do the examination. I say, "Hey, Mr. Jackson, can you? I need to know these things." And he goes, "We don't have those things." I'm like, what do you mean you don't have these things? You mean you don't have them yet? Can you guys no, Mike? They didn't get these things, and it's just your traditional things. Like I wanted to see documents of the timeline. I said, hey, where's their timeline? Where's their chronological record from their investigation? When did they do things, and why did they do things? Like normally, what I would see, and I would put this into the thing that I would say was the the overarching aspect of their investigation was there was no case management. There was no proper case management from the moment they arrived, which you think of crime scene management, all the way to the collection and preservation of evidence, to the documentation of evidence, and then to the presentation of evidence. There was just no real like you could point to, oh, here's the case management system they use. And it doesn't have to be fancy. You don't go buy some fancy program. Folders and subfolders and good names for documents can get it done. And I actually wrote that down earlier was the Colonel Noble in his comment. He said one of the things that he intends to work on is case management. So he saw that. It's not foreign to anybody over there.
Yeah, and I think that when you look at how everything was done from the top down there, sometimes it can be by design. Sometimes it can be
Right.
intentionally vague. They didn't write it down, they didn't record it, there's no chain of custody, and you still go to trial on it and just ask the jury to take a cop's word for it because some jurors really will. And I have a lot of personal friends that are in law enforcement,
Yeah.
and sometimes they'll call me and be like, hey, I screwed up on this report. I got my depo today.
Right.
What are they going to add? Like, how can I deal with this? I'm like, eat it. Like you mess up a report, you're
Right.
human. Well, why did you mess it up? How did it change anything in the investigation, if at all? Did you correct it? When did you correct it? Why did you correct it? How are you going to do
Right.
it better? And that's it.
Right.
And most of the time, if you are a normal human being on the stand as a law enforcement officer, jurors are going to accept that. But if you're
Right.
not, which you as somebody who coaches, trains, teaches expert witnesses and law enforcement witnesses, there's a lot of questions that people always have about, ask him what he thinks about Dever and Buchanan and the people that the jury saw, because we know now because of their interviews, legitimately evasive and
Mhm.
argumentative. They wouldn't admit anything. They wouldn't eat
Right.
anything. And just how much worse does that make it when there's this many warts on the investigation?
Yeah. You brought up two good points. The jury is quite forgiving, I've found. If you just admit you made a
You
mistake.
guys, not so much us.
Well, I would say on direct, listen, am I perfect? Absolutely not. Have I gone on the stand and sat there and looked at my report and went, guess what? Didn't notice that error. And
Yep.
in the FBI, we'd have our reports peer reviewed to
Mhm.
collect errors. And you're immediately thinking, I missed this. And I'll give you an example. I don't remember the date, but I remember specifically I was testifying and I said, ladies and gentlemen, on slide 9, you see the address of the crime scene location. And I read it. And as I read it, no one picked up on it, but I did. Hmm, that's not the right address of the crime scene. And I paused. I said, ladies and gentlemen of the jury, I need to point out that I have an error on this slide and I apologize. I know that that's not the correct address for this crime scene, and I want to make sure the record's correct. If we go back to the previous slide, I did have the correct crime scene address. I'd like to point that out to you now. And I pointed it out to them, and then we went to the next thing. And that case resolved in favor of the prosecution. And what did I do? I humanized myself for a moment and realized that, you know what? I made a mistake, but I didn't try to hide it from him. And so that would be my second point, Peter, is that I don't think the jury is very forgiving when you try to mislead them. And
Mhm.
whether or not these people are experts in, criminal investigations or body language or themes they use in defense and cross-examination, people get a pretty good sense when you're BSing them, right? And you sit there and you start seeing these interactions. I would say that that was a huge issue for the government witnesses and specifically law enforcement witnesses, which you would think they'd be the standard for credibility of witness and the experience. But instead, I thought Yuri, I mean, we don't even have to say Dever. I mean, it was so, I mean, I've already snipped it because I'm just going to play it as a sort of a comedy. I don't say comedy, that's unprofessional,
No,
but
as a teaching point, because people ask me what's going to be taken from this trial as a teaching point, and you just answered. You teach expert witnesses and law enforcement. You're going to use
right.
Devers' testimony as what not to do.
Right. In watching your recaps, what I would do was you would pick up on key things. I'd be like, "Ooh, he's on to something there." I'd go back, watch their testimony, and I'd snip it, and then I save it for the defense teams. Like, and I teach the students is, I want you to hear the question, and I want you to think before I play the response. How would you have responded? Now let's listen to the response. Do you think that was the best response? No. Let's talk about why it wasn't. And so it gives people a real feeling of, oh, how would I answer that question, right? What does it make me feel? How should I respond as a law enforcement witness? Um, I lost my train of thought there, but I think the second part is the law enforcement witnesses, and Colonel Noble said it too, is that they need courtroom testimony training. He said it in his statement. And you saw it, Peter. I think your audience sees it. I think the world saw it, is that as somebody that teaches that, when I watched Yuri's demeanor, I didn't like the way he sat there like he was on the king's throne. I didn't like that at all. Um, Devers' just emotional reaction to everything was just so poor. I mean, if we were to have a conversation about Dever just quickly, it would be Dever could have come out with flawless. All I would have said is Devers, be honest and tell the truth. The jury would be fine if you misremembered something. It could have simply been, are there computer screens in the 911 center? Yes. Did you see them? I did. Were you watching them consistently? No, but I did watch them intermittently. And it was your statement that you saw these two individuals enter the Sally Port. Yes. Let the prosecution came back and say, well, that wasn't true, was it? Well, it was true that I saw it. Perhaps I saw it on another day. I don't remember the exact date. And I apologize. I wish I had a better memory. I wish I could be more helpful, but that is what I recalled. Dever walks away. Okay, well, I'm okay. I just walk back to and go back and patrol. But instead, that reaction was so horrific to me as somebody that teaches this, and even I think you're layperson. That's why they bring her up. Is it was just so bad. I can't even. We could have a whole class on Dever's response.
Yeah, and it was like it reminds me of when I was in law school and we did mock trial, and the lawyers also had to be the witnesses. We'd be the fake witnesses.
Mhm.
Law students have to be the most annoying, miserable witnesses to deal with and cross-examine because we all think we're so smart. We think we know where somebody's going. We think we
Right.
can give a pot shot back. And that's how it felt like she was doing. Any chance she was going to try to take a shot at Jackson, and it just doesn't come off well.
Right.
And I mean, yeah, I think that's great that you use that in your classes as far as what not to do. And I'm sure you can think of many things in this investigation to do that with. Some of it's obvious, right? And some
Right.
of the misery was obvious to any layperson. That's basically why Judge Canoni, in my opinion, didn't let you necessarily testify. I also didn't get the vibe from the defense that you were just going to be talking cell phone. So that's why I thought it was an even broader scale based on what they wanted to bring you in for, which I think is completely fair game. And like I said, we've seen that.
Right.
What is it, do you think, that you would have added that a layperson or the common man or woman would not know about how bad this investigation really was?
Hmm. I think I would have been able to explain to the jury that what they did is abnormal. And they already sort of picked up on those things, but those are the bright light things I would say is I think they probably thought it was clearly suspicious, the red solo cups and the leaf blower and the shop and stop bag or whatever it was called.
Mhm.
But there's a lot of more fine line things and I would say that would be more of my testimony would be, why is it important to preserve the crime scene? Why is it important to photograph, diagram the crime scene? Why is it important to keep a log of who has come and gone and what purpose they were at the crime scene? We would have a log of anybody that comes to the crime scene. Who are you? What are you here? What time did you arrive? What's your badge number? And when you left, we would sign you out. What time did they leave? And so we have a good idea of who's interacted with it because we've secured it, right? Um, I would have loved to have seen in that crime scene response a really good diagram and a video of what it looked like when you arrived. How was it when you arrived? How was it after you left? And that way we could have seen over time how Yuri described that the evidence kept revealing itself to us. I think the jury, if we had a video of what it looked like when they originally arrived, we could then see over time, because they arrived what, the 29th, the 3rd, the 4th, the 8th, the 10th, the 18th, I think were all those days, right? Okay, if the evidence is revealing itself, show us the scene. And why did it keep revealing itself? I would have loved to have seen a ruler, those evidence rulers stuck into the snow to see how deep the snow was each time you came to show, hey, we found these things like an archaeologist would have found them. At what layers in the snow did you find these things? And they could have tried to have done some type of assessment of, well, if it's at this level of snow, that would have had to been between this time period because there was only a track a cat amount of snow at that time, right? I would have loved to have seen those. I probably wouldn't have gone into all those details, but then I would have moved into once we've secured the crime scene and collected evidence from there, what are the next logical steps as investigators? How do we then identify people? And I thought this was critical is at no point did they have a witness, suspect, or potential suspect list. It was just from January 29th, Karen Reed was the sole suspect, and every other person that was at 34 Fairview or came in contact with John O'Keefe that night and the days prior, or the nights prior, or the hours prior, were witnesses. And they were immediately considered witnesses and treated as witnesses the entire time. And I'm not saying they wouldn't ultimately be a witness, Peter. I'm just saying I thought that was premature to designate what happened so quickly with so little investigative activity. And I think that goes to we could talk about bias, right, or prejudice. I know a lot of your people that watch this feel like that's what it is. And I'm not saying that couldn't be it. I probably would have taken a more objective look at the evidence and just said they never collected enough evidence by the time they arrested her on February 1st to determine that she was the sole suspect and that a collision definitively have occurred and that the injuries to John O'Keefe were consistent with a vehicle collision. And so then as a team, we go, okay, what are some other possible theories of how John O'Keefe came to be on that lawn and came to sustain those injuries? Let's take a step back and war game or conceptualize what are some theories for this. And I would have started with John O'Keefe's phone. I would have gone back to his cell phone records themselves from his service provider. I would have mapped out what he did the days before. Who did he text? Are there any other people we're missing in this story? And I would have described those elements. And then ultimately, I would have described what are the advanced investigative techniques that could be deployed in this to better determine a timeline and how do we develop really finite time because this case is the timeline case. People have to be in the right place at the right times for these things to occur and presented a very nice. I think I would have presented a nice, but I think ultimately, I think Massachusetts maybe has some different laws, but in California, especially in Fed court, we love our demonstrative aids or
Oh,
chalks, I
yeah.
think was what they were referring to.
Yep.
We love making charts and diagrams, and I think if you're looking at your jurors, is they're just regular people like us, and they learn. Some people learn by seeing, some people learn by reading, some people learn by hearing. So why not give them that third? Show them what it looks like. Show them a timeline. And you know who had some of the best chalks? Alan Jackson's team, the Karen Reed's team, right? Remember that chalk about let's stop calling it 1x 5 4 3
Oh
2
yeah.
1 and then
That chart, the
let's just
glass
call
chart.
it the glass. I thought that was amazing. So I
Yeah.
don't know if that hits it for you, Peter, but I'd be happy to expand if you had some
Well,
questions.
especially the first part of your answer. So a lot of times if I do have some questions, which I'm not even looking at my questions, but I was thinking through some questions I wanted to ask you, and that was one of them. And I write down kind of what I want to hear or what I think the answer is. And the first part of it, of your answer was really the most important thing. The jury needs to understand why. Not just that red solo cups are bad or no chain of custody is bad, but why is it bad? Why do you have procedures and protocols? Why do you stick to them? And what can go wrong when you don't, right? And that's what Judge Canoni, to me, just missed the boat on, is not that, yeah, sure, this is embarrassing. Anybody can tell you it's embarrassing. But when you have cops coming up there saying, well, it was snowing out there and it was windy and, whatever, and giving excuses for the jury to think, okay, that's normal. That's where someone like you, I think, would really come in and say, no, this is not, weather is not something that we've never dealt with before. Having to drive back to the station for something is not something we've never dealt with before. This is why it's so important to hit the protocols and procedures. And you hit it right on the head, because that's what I think would have really helped this jury. And with the demonstrative aids and stuff, you said it was weird because sometimes it felt like they weren't allowed to use a bunch, and then others, they were entering their PowerPoint presentations of experts into evidence.
Right.
And I was like, that seems strange. That's a
Right.
new one.
Yeah, I
It's a
found that
little
strange
weird.
too. Yeah, my demonstratives, because I make maps a lot in a
Mhm.
report, and I use that as demonstrative to illustrate my opinions and conclusions for the jury. They don't always go back with the jury. It's pretty rare, in fact, that the PowerPoint itself will go back. The
Yeah.
underlying records, which is the foundation of my testimony, do go back. And I've even had questions. They're like, "Hey, can we go back to Agent Easter's testimony where he said how we look at the records to map them ourselves, and the jurors will do those. I've seen, or I haven't seen it, but I've heard jurors wanting to do those types of things.
Yeah, absolutely. And you always have it's always like bittersweet when you have a good demonstrative aid that they ask, hey, can we bring this back here with us? And we're like, no, you can't. Sorry.
Right,
So usually when you learn that, it's like, you can't bring this back with you in closing arguments. I'll be like, so write this down, or,
right.
write down whatever notes you need to remember this when you go back there. So
And
the cell phone, go ahead.
I was going to say you're right, and that's where being a good witness is, and that is one of the things I teach in expert testimony. Is remember your testimony needs to be a word picture. So when you say on page 9 over here and over there and up here down there, or right here at this point, that does nothing in the readback to the jury. The jury's still confused what your testimony was. Instead, be very descriptive, and it sounds silly, but you're going to say, ladies and gentlemen, on page 9, my map in the upper left corner, there's a green icon with these letters. That green icon is the crime scene. You can see the tower references, tower reference 1 with the red shaded. You know what I mean? You sound like you're like, oh my God, this is ridiculous. But I'm painting a word picture. So if my testimony gets read back to you, you're like, oh, I remember now what he said. That's right. That's what happened.
Or if you have really serious note takers, they're going to be able to take down exactly what you're saying as well.
Right.
So the cell phones in this case somewhat took a backseat with the defense's no
Right.
collision, reasonable doubt, but also some of the strangest cell phone testimony I've heard, right? And I'll just throw
Yeah.
a couple things out there and you kind of tell me what you thought, how weird it is, why it's
Mhm.
happening like it's happening. The 227 Google search, how's long to die in the cold versus the 6 a.m. and the testimony back and forth. We had that. The differences between trial 1 and trial 2 about where the phone was, whether it's going up and down steps or making 3-point turns, and how they tried to use that to prove a timeline. This might not be fair. Also, me throwing a very compound question at you, but
It's all
just
right. I'm going to take a note.
there, and you tell me like which one stuck out to you. The way that Brian Higgins, quote unquote, turned over his phone, right? Because they made it sound like, oh, this is all totally normal. He turned over his phone. They can do whatever they want with it. The way he destroyed his phone, which of course didn't come out in trial 2, but there was just so much cell phone data that was somewhat available in this case, but it felt like each side tried to use it to their advantage. But I never really felt confident in what was being told to me as the general public. And the jury really didn't mention the cell phone data much at all. Oh, and they tried to use the battery temperature to like absolutely prove their point. What were your thoughts about the cell phone data generally in this case?
Yeah, maybe I'll offer this as the general comment is that as somebody that does this for a living and has an expertise in it, I did what the jury did is I discounted it, and the reason I did that is when you have two conflicting testimonies and they're both reasonably compelling, they just sort of cancel themselves out. And in that instance, the jury, I think we would see, and I've seen it, before. Well, we didn't take it into account because we couldn't make sense of it. Nobody could explain it to us accurately, or both people seemed right, but and they both contradict each other. So I didn't know what to think ultimately. So it's like their brain just goes, I ain't using that anymore.
Mhm.
And so I thought there were some novel techniques here that I've never seen anybody use the battery temperature. I think if we wanted to talk about a Daubert or Fry type of hearing, I mean, newer novel technique of using battery temperature to determine when somebody's outside. I mean, I've never seen it in my career. I've never heard of anybody doing it. Do I think it's a reasonable option? I think so. I mean, why not? Why not try it and see what happens? But I just don't think the test was scientific enough that it
Well,
really mirrored the conditions for O'Keefe.
I think it should have just been an argument the lawyers make, and you can put in the chart of the battery. I think you're right
Yeah,
that the expert's trying to add something to that. That's not what an expert does. You're here to explain something I can't
right,
explain because I don't know. I don't have the knowledge. It's not super
right,
logical or obvious. But all they were doing with the battery was looking at a number and making an argument as to what they think that number meant. but the experts
Right.
really, I agree with you completely. I don't think they added anything scientific to it.
Yeah, your job as an expert is to interpret the data. You're an
Mhm.
interpreter. I always look at it, think of it as a foreign language that nobody's familiar with. My job's to interpret it for you and offer an opinion of what I think the data says. I thought they went beyond that here with that test. Now I'm not interpreting, I'm conducting scientific experiments to sort of randomly support my interpretation. And I
Mhm.
think I 100% agree with you. It should have been better just presented as a very basic concept and argued in closing. How, like, the example, how else, ladies and gentlemen, did his phone go from this temperature to this temperature if he
Exactly.
wasn't outside, right?
Exactly.
I totally agree with you there. Um, as it goes to the Celebrite extractions, or even a forensic extraction of the device, those things can be a little finicky. And I'll be honest, depending on what software version you have in your Celebrite, it would depend on what things you get from it. And you'll see that I've seen in my own personal cases where we've downloaded a phone, things weren't there. We re-download it 2 years later prior to trial because the defense wants to download it. All of a sudden, the new software gets things out of it that we didn't have before. And it's like, did we purposely try to hide something previously? No, not necessarily. We just didn't have access to it based on the tools that we had, and the tools changed. I would have loved to have seen for McKay because she was so critical, right? Really critical to time. She was originally in the first case, the 1245 person for that text of seeing the SUV, and
Mhm.
why Trooper Paul and the Trooper Proctor chose 1245 to write in their report for the accident, right?
And the
Um,
extrapolation, they looked
right.
back 1245 for her blood alcohol
Right.
level.
And that was their whole original theory in that first case was 1245, which never worked because we have a voicemail from Karen Reed being at home prior to 1245, right? I think it was around 1239 that she made that call.
And her
So,
phone connecting to the Wi-Fi at 1236,
right.
which was a big one.
And imagine this, Peter. Imagine if you had a really good timeline of all this and
I
you saw the
know.
1245, you would have been like, hey guys, he can't be hit by her at 1245 if she's already at home. And they
And it
didn't
was
really,
another like intentionally vague thing in trial one where we never really knew when they were saying the time of death was. And it changed a little bit in trial two, too,
right.
which if you had your timeline of the cell phone
Right.
data, that just makes no sense.
I totally agree with you. And the reason that, we saw that time migrate in the first trial and in the second trial is because of things they learned through testimony. Is like, oh, we got to migrate this a little bit. It doesn't make any sense, right? And so then it's like, well, then if your time can migrate throughout the trial, then it's not really accurate. And that's unfortunate then because that means you didn't do your job. And Peter, I think you could, if you did a really good job in this case early on, you could have said, we can't pinpoint the exact time, but based on our approximation of the evidence, it's between 1230 and 1239 or 1236. Give a window and just say, we've based this opinion on a reasonable inference of the evidence. And we want to walk you through why we come to that conclusion. I think you could have got the jury to a time period of, let's say, 5, 6, 7 minutes, instead of trying to get Burgess to get you down to the half a second that he was doing. I just thought it overstated the evidence, and overstating the evidence sometimes can really be supersede as mischaracterization of the evidence. And I would have, if I was consultant, I'd be like, guys, why do we got to tie ourselves to this exact second? There's just not enough there. Why can't we just agree that it happened sometime in this window? And the evidence doesn't give us that finite period. Like, if that's not enough, then we need to reconsider whether or not we should take this case to trial.
I was going to say, you know why you're wrong, Mike? The
Why?
problem is they can have whatever timeline they want. If you
Right.
can't prove a collision, like here's the real point. You're thinking about this as a normal case. If this guy's got broken bones all up and down his body and bruises all up and down his body and he slid across the grass and we can prove all of that, the jury wouldn't care. They could say it was sometime between 1225 and
Yeah.
1240. I don't care if her phone connected to the Wi-Fi. They would have convicted every single time. If you can connect her Lexus to his injuries, they would have given you all kinds of grace with the timeline. The problem is they were trying to make the timeline so perfect down to the 29
Hmm.
seconds or whatever you just said
Right.
in the half a second to make them think, well, maybe with the timing, it's the only thing that could have happened with these key cycles and almost distract from the major issue in the case.
Mm.
And I'm sure you've seen maybe defendants do that against you, trying to use the cell phone data to say something that it just doesn't really say.
Right.
That's what it sounds like you're saying here with the
Yeah.
time.
Yeah, you bring up really two good things. One, this is why I think our conversation's interesting. Is you're a lawyer and I'm an investigator, and we both see the same evidence and how we would present it slightly differently. And I'm still learning that I don't work for the government anymore, and I'm always constantly trying to prove something happened. And as a defense
Yep.
attorney, your job's not to prove something happened; it's really just to prove it possibly didn't. Um, so I appreciate that. Like you, I'm still learning what it means to be on the different side of
We're never
proving
going to stop
proving
learning.
elements of a case.
We're never
Um,
going to stop learning.
yeah, I keep looking. I'm like, man, we could do this and maybe prove something happened. And that's just how I spent the last 20 plus years
Sure.
trying to do that. The second part you brought up, and I'm drawing a blank on it. What was it? What
Well,
was?
let me interrupt you again. People always hate this, but this is just how it is on my shows. I want to get it all out. I want to hear what you have
Yeah,
to say. And you just made a really great point, and I think that's an asset. What you just said is an asset to any defense firm you work with now, that you're thinking of all the different ways you can prove it. And you know what you need to do to flip that is to say, the reason he's like, oh man, we need this to prove it. And the reason I don't have it is because they didn't get it. And in this
mm,
case, that could have happened so many different times. Like, yes, we could have proved this, but you know why we can't? Because they didn't do this. They didn't take this
right,
picture. They didn't record this interview. They didn't take the video of the Lexus in the Sally port. They didn't photograph. So you think exactly what you need and you
right,
write it all out. Here's what Mike Easter needs to prove this case. And these 6 things aren't there because of the lack of the investigation. And then you've
right,
got your testimony. Like that's
right.
that's what
And
happened in this case.
and that it's really great segue. That is essentially what I did in the report is what did they do? What is their policy? What is the best practice? And how would I have done things that they didn't do to fill in the gaps of this
Mhm.
investigation? And yeah, I would have. I depends. I don't get to ask the questions, but it depends on what I'm asked on the stand. But I think Attorney Jackson would have done my direct. Mainly because I don't want to say we've worked together before because he actually was cross-examining the last times I've seen him. Um, but nonetheless, he even in being cross-examined, stylistically, we would have fit together, and you know how that works, of course.
Well,
So
that's a
it,
big
it would have played a
compliment.
little better.
If he was
Yeah.
crossing you last time he saw you, and then now he wants to hire you on his team, that's about as good of a compliment as you can get. And we've done the same thing. And sometimes that's how you
We
find the best witnesses.
and what's interesting is he called me originally and said, Mike, this doesn't sound like how you described things previously. Were you wrong or are they wrong? Can you look at it? And I was like, yeah, this isn't right. So
What about the Higgins phone download? The way he gave it. What can you not get that based on the data and information that he turned over? I'm assuming there's a lot that you miss out on as a cell phone expert.
yeah, I let maybe address just the concept of that. I mean,
Okay.
anytime a witness tries to collect their own evidence and give it to me, I'm suspicious. My suspicion is, what don't you want me to see? Because those things that you don't want me to see are the things I want to see now.
Mhm.
And so to answer your question fairly is clearly his use of a third party to extract his communications between him and Karen Reed, and I think he provided John O'Keefe's his conversations with John O'Keefe. Um, is part of the story. And we look at this case, that's all we've ever gotten is parts of the story. And so your job as investigator is to get the complete story. You should not be satisfied with Brian Higgins giving you part of the story when he is intertwined in the story from its beginning to its end. And so now it's my job as an investigator to go out and collect the rest of the evidence Brian Higgins didn't want me to see, and I would have done those things.
Yeah, I would have loved to see Jackson do your direct because it is one of my favorite things, and my dad is so good at it too, especially because he's done state and federal prosecuting. But longtime prosecutor, longtime cop slash FBI agent on the other side, right?
Right.
I mean, we learn as prosecutors and then as criminal defense attorneys, crossing officers, we know the policies and the procedures. So we know what it
Right.
should be, right? We're not an expert, we're not an actual officer, but we know what it is because we ask the questions all the time. And that would have been a really fun direct, I think, with both of you to be able to, paint this beautiful picture of what it would look like. And you probably wouldn't have to say anything else. It would be so obvious how
Right.
inept this investigation was and this prosecution was.
Yeah, and I did demonstratives to that. I showed this is what they did. This
Mhm.
is inconsistent with the Massachusetts State Police Policy Guide that I got from the internet, and I made snips of it and compared it. This is what they said and did. This is their policy on evidence collection. This is their policy on crime scene management. This is their policy on separating witnesses. This is their policy on X, Y, and Z. And then I put this is what I would have done, and this is what you would have got from it. And I think that demonstrative would have just really solidified, and I think the jury got it right clearly.
Mhm.
They saw it, but I think maybe I'm just selfish in thinking it would have been interesting to present something that you worked hard on to present, and it would have been enjoyable.
I mean, obviously, listening from the jury now, it's hindsight's 2020. Maybe it would have been
Yeah.
overkill, but I think that, and it was the same thing I said. One of the defenses they had in this case, I could have built an entire case around, entire defense around. They had 10 of them,
Yeah.
or maybe
Right.
more. And you
Yeah.
were one of those multiple ones that they had. Amanda asked how you think you would have done with Hank. Have you had
Hmm.
lawyers that you feel like maybe try to get personal or make a big deal out of something that is not? Because again,
Yeah.
you've been crossed by a lot of defense attorneys, 200 trials as a prosecution witness. So
Right.
how do you think that would have gone now that you've seen the trial and seen kind of his style?
Yeah, I've been cross-examined 200 plus times, and that doesn't include, pretrial,
Right.
Dauberts, Fries, evidence hearings, and that kind of stuff. And then my own personal trials. Those 200 plus trials were someone else's testimony or someone else's case where I was an expert in. Um, Listen, I know everybody has strong opinions about Brennan. I think Brennan is a very, very skilled and smart attorney, right? People may not like his style. I personally don't like that style for a prosecutor. I don't think it's an effective style. From my experience working with prosecutors, I wouldn't have, not that he would have wanted my advice on how to be a good prosecutor, but I don't like that style. Your job is to bring the truth, not to hide
Mhm.
it. And I think he should have been more of a champion for the evidence than try to hide it. I think he would have been very challenging for me because I'm naturally, you can probably just see from our interaction, is that I like to explain things. And I like to, I'm okay being giving it back to you a little bit, but you have to remember that who you are as a person and who you are as an expert don't have to be 100% the same. I always think being an expert, your job is to be the best version of yourself. You don't
Mhm.
want to try and pretend to be somebody else because then you lose authenticity. But that doesn't mean that you need to be your full self in every aspect of it. And so I would always encourage people, be yourself, try to be as interesting and charismatic as possible. But the most important thing you can do is listen to the question you're being asked. Understand why they're asking it to you. And this happens in real time. Your brain might catch on fire, but understand what they're asking to and answer just the question. Your job's not to try to score points for one side or the other. Your job's not to protect the other witnesses in the case. Your job's to be there is to answer the questions that you're being asked, be honest, and at times you're going to naturally score points for your side, and you're naturally going to give a little bit of points to the other side. It's just going to happen. Don't try to always be the one scoring points. You're not the only witness in the case. There's other witnesses, and ultimately you really in most cases you have a small portion of it. Do your portion correctly.
Like Bill Belichick says, right? Do your job. Just do your job.
Right. It's a great analogy is if everybody does their job correctly on the football team, we win games.
Yeah, exactly. And I think it's complex but simple enough because sometimes people
Yeah.
struggle to do their own job. And another thing I really want to talk to you about and get your take on is the federal investigation.
Yeah.
Have you ever been a part of a situation where they are investigating other potential law enforcement or government actors for their actions, and the FBI comes in and does some, or DOJ comes in and does some kind of investigation?
Yes, and maybe I'll just clarify that just a little. Is the Bureau has violations or programs, and those top programs are counterterrorism, counterintelligence, cyber, public corruption, and then it sort of comes down to violent crimes. I was never assigned to a public corruption or civil rights color
Mhm.
law squad. That I wasn't assigned to one of those. But because of my last 10 years as a national asset, I would have provided investigative support to those squads, and I've provided assistance to public corruption squads in the analysis of cell phone records and other location-based records. So did I investigate their case as the lead investigator or co-investigator? No. But did I see those cases and I'm familiar with them? And if I testified in them, yes.
And talking about how that works, and just generally speaking, when something like that's happening, uh, does the FBI always alert their targets that an investigation is open and that they are a target?
Never.
Okay,
Well,
not
the goal would
maybe
be never.
they do at times, but definitely not. It's not an always thing.
Yeah. Can I say this, Peter? It might be a strategy. If we've notified you, it's a strategy that we've decided is important to us because we want to tip you off to start what I would say um, trying to bring in other co-conspirators by bringing them into, hey, telling them your theory. Like if we tell you about your case, I'm sure I'll say it. You probably should stop talking about your case with anybody you know. You should not make any phone calls. You should throw your phones away, throw your computers away, and start fresh. And if you're smart, because if I've told you about it, I've been watching you for probably months or years.
Yeah,
And I'm
maybe we'll
close to the
destroy it,
end. I'm
but,
close
but
to the end. I'm
put it
about
in
to
a
arrest
drawer.
you.
Yeah, yeah.
Yeah,
Put
I'm
it in a
about to
drawer
arrest
aside and
you.
call your lawyer. Call your lawyer.
Yeah.
But
Or
yeah,
maybe do
so
what Higgins did, throw it away and on a military base
oof,
and forget
yeah,
about it.
that doesn't look bad. So that's when it starts, and then the opposite can be true too, because I mean, I've never experienced, somebody absolutely closing the book on a target as a federal investigation. I don't know if you
Right.
have, but that can also be a strategy as well. Oh yeah, we're done investigating you. That doesn't actually have to be true, right?
Yeah, I really would take issue with the word close. I think Brennan might have perpetuated a story to benefit himself. I'm not saying he's lying. Don't take that as what I'm saying, because I don't know what the conversation was with the DOJ, but I can tell you from my experience of working there 20 plus years that I've never once informed a witness or a third party, especially in his position, former defense attorney, what we are or not doing with our case. I don't owe you a response. I'm not telling you whether it's closed or open. In fact, I would just prefer to keep you in the dark. That's how I would like this relationship to go.
Yeah, we
So
kind
I
of joke.
I think I think they would have probably told Brennan or them that the FBI and the DOJ have completed their investigation at this time. And we're not giving you any more new evidence. We're not doing anything more as it relates to your thing. You guys are on your own. We're not providing any more discovery to you in our investigation. And ultimately, did they close it? I don't know. Could they have? Yes. Is it just as likely that it's still open and they're waiting because the DOJ has never done anything impulsively and they're really happy to wait?
Yeah, and some things sort themselves out. Number one, but also it does not. Or I'll ask it as a question. Does it at all hamper or hamstring or make an investigation any more difficult just because they said they've completed it this time, or even if they did say they closed it at this time? Does that have any negative effect on if they want to look into it again in the future?
No. Closed case can be reopened with the stroke of a pen and an electronic communication to the file that we're reopening the case based on new evidence that we received pursuant to a review of uh, such and such's testimony at trial number two.
Exactly. And so
And actions afterwards. Maybe those public corruption cases. There's I would say this, Peter. There's never. What's the rush to close a case? Why rush? Time's on our side. I don't have to rush. There's no timeline. Don't somebody says,
right.
"Well, Mike, you have to have this closed by X." Especially a public corruption case. Those things tend to only get better with time.
Yeah, people usually are just continue to be themselves. Um,
Yeah.
yeah, and a lot of people have questions about what happens now and what can the DOJ/FBI do now. And I want to add to that because I've seen some reports, and I'll be very careful to say some reports of what jurors are saying that they really want justice for John O'Keefe's family, and the public is
Mhm.
pushing reopen this, look at this again, figure out who really did this. How does the FBI deal with, I'll call it, public pressure or people making comments like that? How does that affect the way the FBI does their work?
Mm. I would say in most instances, the Bureau, or at least the DOJ, the reason we sort of historically have stayed in the shadows is we don't really want to be affected by public opinion. I don't think you should investigate things because of, the public feels strongly one way or the other, because half of the other public, or maybe not full half, maybe 70-30 in this case, feel the opposite, that the right thing was done, right? So I would say this, Peter, is that um, I'm trying to think of a good answer for you on this one. The FBI or the DOJ, they're not going to, and this is just for me as a retired person, they're not going to come in and reinvestigate the John O'Keefe truck case, his death. The Bureau doesn't have an investigative platform for that. We don't have a mechanism to charge state violations, murder, second degree murder, manslaughter, or OUI. We don't have mechanisms for that. Instead, what we do, if you look at our top priorities, people can go on the FBI's website. What is I think it's number 3 or 4. The number 3 or 4 priority is public corruption. So why is the FBI in Canton, in Massachusetts? It's not because of John O'Keefe's death. They're not investigating that. They're determining whether or not the people that were investigating it did it ethically.
Yeah. And I think that if I was going to give my answer as to what I thought, the DOJ, the FBI, they care about the people that they protect. They care about the nation. They
Right.
care about the citizens. They're not going to let that affect their decision making. And that should be a good thing that makes us all feel safe, that I can spout off and then I can be like, oh, we better do something now because, this guy or this 50 people think it, because that's how you can make mistakes. And that's how you can really get yourself into a lot of trouble. And the fact that they looked into it at all, if I was them, look at the positive effect it had, right? It gave people some validation of the shenanigans that were going on. It made ARCA enter the equation. And they had a serious positive effect. And then also from your perspective as a former FBI agent, when you find something that's good for the defense, what do they usually do? Like, what do you do if you have an expert, or you have a reporter, you look at a cell phone and you're like, he couldn't have been there. I looked at his cell phone. This target could not have been there. What do you do?
Yeah, I have an obligation to produce that. It depends on the nature of it. If we're early on in the investigation, I would exclude that person as a suspect. Okay, clearly they don't work as a suspect. And I get oftentimes, when I was Agent Easter, you've exonerated people. And I always say, well, exoneration is a legal outcome, but I have excluded people as suspects hundreds of times, right? But I really think back to one case I really remember well, is how dumbfounded the defense attorney was when I turned over the maps that his client's phone wasn't there. And the prosecutor, I talked to him, I said, hey, listen, you sent me these records. I just want you to know, do you have the right suspect? And did you give me the right phone records? And he goes, yes. And I said, okay, if this phone is on the defendant's body at these times, then that person could not have committed the homicide. It's not possible. If that phone is on their person, they're not there. He goes, okay, well, I need you to write the report and I have to turn this over. And can you do that? I said, yeah. He turned it over. And I remember the defense interviewed me. They asked for an interview. Like, so you're saying he says he was over here? And I'm like, yes, I'm saying that is where he was. He's like, so they have the wrong guy. I'm like, I don't have any opinions about that. I'm just saying that his phone was where you said it was and where he said it wasn't during his statement. And so, yeah, that happens. And you know what? I didn't get in this job to just put people in jail. That's not what I got in the job for. I got in the job to get the right people in jail, to get people that are committing crimes. Just putting people in jail, I can't imagine anybody signed up for that job.
Yeah, but with the power you're given in those positions, you can pretty much do that. Like that's the scary part is, I mean,
right.
You can do that. Like the power that is in certain individuals' hands. That's what makes this so important, right? And that's why people care so much. That's why people want it to be looked into, because if there really is the corruption there that it seems like might be there after viewing this case in Sandra Birchmore, it needs to be looked at. And I think at the very least, we know it's on the FBI's radar. Because they even did the initial investigation. And can you talk about that a little bit? So let's say you open an investigation, maybe it, you complete it, it's closed, whatever it may be. Is it still something that is monitored, can be monitored? Once it's open, is it easier to reopen? How does the FBI look at things like that?
Yeah. Again, a closed. I personally don't think they would have just straight up closed it that quickly, only because the people you're investigating are still doing the investigation of why you're there, and false statements can still occur throughout the trial, and you got to remember a lot of these people have been interviewed and given the 1001 admonishment. So if they're going to continue now to lie on the stand under oath, well, then did you lie to me because you're now have a different story? And I think the fallout from this, who's going to come forward and then start pointing the finger at other people in the investigation? Well, I still want my case open if I'm going to use some of these people. And I would also say, I don't want to get too far into the weeds here, but there's other investigative strategies that may still be rolling and collecting information while their trial is going on against those parties. And so we want to be able to have those access or those things that are collecting still extracting during the trial. I wouldn't have done that prematurely if I was doing it. If it's closed, surely you can reopen these things, especially if new evidence. You wouldn't just open it on hey, I saw something in the media. You'd want some predication to reopen the case. But the Bureau really is a very slow machine. We are slow to respond, slow to investigate, and slow to prosecute. And it's by design. And it's by design is we like to let these things mature and marinate and collect and develop our investigation. And when it's right for us, take these things down.
Yeah, I really think that the way the FBI looks at things is so abnormal to your everyday person that it seems more black and white. It seems more cut and dry. They can't understand. Well, why can't we just call somebody in and ask them if they close this investigation? Like those are a lot of the
Right.
questions that we get. And and I think, I don't remember if I said this even before we started recording or after, but my dad and I have had trials in federal court with FBI agents where the FBI agent and the U.S. attorney and the judge will stay in there in the middle of a criminal federal trial where our client has rights, and they will send all of us out of the courtroom and make some decision on a piece of evidence in the middle of a cross-examination. My dad was cross-examining a undercover FBI agent, and it was about where they put certain things to record statements and video of our client in conversations. Whoop! Stop the whole trial. We get kicked out. They have a whole conversation. We come back in. They say, "Mr. Tragos, you're not allowed to ask those questions. National security." We're like,
right, and I've had those. We have specialized equipment that is law enforcement sensitive, and luckily for us, we haven't had to disclose those assets
and I
in the
get it.
public.
I get it.
So,
Right. We want to catch the bad guys. I get it, but it's just abnormal, right? It's incredibly abnormal. It's not what you think of like an everyday cop. And the difference in federal court and state court, there's a big difference. We joke
right,
big boy court is federal court. I've tried
right.
civil and criminal cases in federal court, civil and criminal cases in state court. There is an absolute difference. And also a lot of times the FBI agents, like I've become pretty good friends with them. Like they're cool.
Yeah.
It's not personal. Like I've never felt like one of them, took it personal when they get cross-examined or things like that. And so it is a different world. It is hard for people to understand, I think sometimes, and it sounds like we're being amorphous when we talk about federal investigations, but that really is just how it is. And everybody, it wants me to ask you, and I think I know what your answer is going to be to this, but based on
Okay.
what you looked at,
Let's see if I get it right.
I don't. So here we go. So based on everything you've looked at, everything everybody you've talked to, do you have some kind of personal theory of what happened that night?
Oh God. Personally, if maybe I would put it from. Do you want a personal or a professional opinion?
Let's give a personal one. Let's give a
Personally,
personal.
I really feel strongly about investigating Brian Higgins.
Okay. Anything,
Okay.
any reason why, or just what the defense brought up, or?
I I just found his response that night to be highly suspicious. And maybe I dissect it for you a little bit.
Please do.
Um, I find it suspicious that he collected his own evidence for us of what he thought we would want. I find it suspicious that just a couple days later, let me do it in chronological order. Is that I find it suspicious that after a night of drinking, his first thought was to return to Canton Police Department. While clearly I would say under the influence. I think we could all say that fairly. And your first response is to walk around a bunch of other cops after having driven your personal vehicle drunk to the station and do some type of administrative work. I found that initially very suspicious. And one of my things in my report was I think we should look into the nature of Brian Higgins. Does he normally come to the police station between 1 a.m. and 4 a.m. to do administrative work? And if he doesn't do that, why? Is it simply because he thought the weather was bad and he wanted to be helpful? I find that disingenuous. Really, your first thought after a night of drinking was to go move some cars. We couldn't deal with that later. Um, so I thought that I would have liked to seen his access logs to the Canton Police Department, and I would have done an assessment of, is this something that he's regularly done, or has he never come into the Canton Police Department after hours? It's not something he's ever done. Okay, that's okay. That's interesting. We should take this into consideration. I would have got his cell phone records to determine whether or not he truly did provide us all the messages that he said he provided. And I would have done that because during that investigation and in the trial, they learned that he conducted what I say is abnormal, which is to destroy an iPhone 11 that has value, to destroy a SIM card, and then to purposely put them in a remote location that would be unrecoverable to your average person, and not even just be discovered by somebody that might be going through a trash can, right? Like if you were to do it behind a dumpster behind a grocery store, somebody dumpster diving. So he put it in a place that is unrecoverable. And that what's interesting then, it makes the presumption that you still can't recover what's on that phone. I would have investigated whether or not his cell phone records from his service provider are consistent with his statement. Did he go out to that military base? Did the phone disconnect from the network at or near the time he says he destroyed it? Right? And then I would have gone and made determinations of his iCloud account. What does he have backed up on his iCloud account? Why? And I would look for legal process to examine those things. I would have done an examination of his vehicle. The nature of where he was at was also in the area of the crime scene. A good investigator not only develops suspects but eliminates suspects along the way. And I would have then reviewed whether or not he had a ATF issued cell phone, which I can't imagine he didn't. And I would have determined whether or not that remained active throughout that night and even the days and time period after when he's allegedly destroyed his personal phone, to marry up what they did together in unison across time and whether or not he had other communications on his work phone, right? I would have probably asked to interview him again and challenged him with this new evidence and see if I could get him to change his story. And if he came up with an alternate reason for what happened, when let's say, for example, his phone wasn't destroyed, I would have confronted Mr. Higgins. You've previously stated that you destroyed your phone. Here are your phone records, and it shows that it was active for 3 days after that. Would you like to change your story? Right. And if his story is correct, we would have developed that. Okay, well,
Mhm.
you actually did this, and we would have got him to make statements to improve his situation, not only to make him more of a suspect, but to make him less of a suspect, right? Um, what else would I have done with Higgins? Yeah,
Yeah. Well,
I think I know this really will, because you're an attorney, this will probably irritate you. And I don't say this that it's wrong, and I would encourage everybody to do this, especially when
I
you get
know where this is
interviewed.
going.
Is it's okay to have an attorney present. And if you don't have one, just say, you know what, I'm happy to discuss with you, but I need some time to consult with my attorney and I'll get back to you. It's okay to be patient. You don't have to do things when the law enforcement tells you. Don't feel pressured to answer questions, even if you're a witness, okay? You have a right to counsel. And I fully think exercising that right is a fundamental for everybody. However, I just want you to know that I also find it suspicious. That's it. Agent Higgins, I'm coming to do a witness interview. It's only been 3 or 4 days since this crime. And by the time I get to you in 3 or 4 days, you've collected the evidence you want me to have, and you've got an attorney present. It would have raised my suspicion levels of why is he doing these things? I need to make sure I do my due diligence to eliminate him as a suspect.
Yeah, and I mean that's your personal opinion on Brian Higgins based on what we've seen and the unanswered questions and suspicious activity that's been presented like in the trial and throughout this entire criminal
Yeah.
litigation. My only response, of course, as a lawyer, I have to defend us.
Right.
When we are there, you can think it's suspicious all you want, but you're not going to get anything that they say to be used against them that may be
Right.
even more suspicious.
Mhm.
So you know, it's something that everybody's got to weigh. But of course, every normal person
Right.
thinks when you show up to a witness interview with a lawyer, they're like, uh-oh, why is
Right.
this guy? That's a good way to become a suspect or a target if you
Right.
show up with a lawyer. But
You know, it's funny on the other side when people do interviews without their lawyer, and I'm like, why did they get an attorney? You probably shouldn't
exactly,
have said those things.
exactly.
So, so it
No,
cuts both
it's
ways,
good.
Peter. Hmm.
No, I appreciate that. And I think it's a good way to look at it. And I think that's a totally fair assessment. And I think somebody in your position who was doing an investigation, your answer was literally the definition of the combination of the third party culprit and the Bowden
Right.
defense. It's
Yeah.
you have this very legitimate potential third party culprit that you should have done X, Y, and Z to investigate him, and you just didn't do it.
Right.
So that's a huge reasonable doubt all on its own.
Right.
And just the fact that you can make that compelling of an argument, a story, a point about what Higgins did that night, that right there should be problematic to any prosecutor prosecuting Karen Reed in this case. And once
Right.
again, that's, put it on the list of all of the
Right.
major problems that could have been the single winning defense on this case. And it's incredibly
Right.
wild. Before you go, I do want to ask you a couple things. Have you ever heard of any of these three cases? Brian Koberger in Idaho, Donna Adelson in Florida, or the Adelson celebration. I love my automatic celebrations.
Oh yeah.
The Adelson defendants in Florida or the YNW Melly case in Florida. All three of those cases, as with almost every case in today's day and age, have so much cellular data that's being used to map where
Mhm.
cars go, where people are, casing
Right.
joints, undercover FBI bumps, undercover recordings. Have you heard of those 3 cases?
I have. I would be far more familiar with the Koberger case because
Okay.
of my role prior to leaving.
Oh, you did some work on that? Or you're not allowed to say? You're saying just because of where you were at the time. Okay, we'll pick up what you're putting down. Well, if you ever look into those cases, I have thoroughly enjoyed this conversation. I really appreciate
Yeah.
you coming on. I think it's fun to just talk through things, looking at it from different perspectives, getting your expertise, seeing behind the curtain a little bit
Yeah.
on how you guys look at things from somebody that's ethical, professional, real life experience, but also not trying to do too much, as I say. Like
Yeah.
anybody that tries to do too much is when you can really step in it, whether it's law enforcement, lawyers, judges, doctors, whatever it may be, witnesses that try to do too much on the stand.
Right.
So I've really appreciated our conversation. And if you ever look into those 3 cases, let me know. I'd love to talk to you a little bit about, because also here's another thing that I'll say. If you can do this, you're a real gem. If you can
Okay.
make talking about this cell phone data interesting and exciting on a YouTube video, because those are the days that when I'm listening while I'm working, I'm like, oh,
Right.
what did they even say? The
Yeah.
only way I can do it, honestly, is with the maps. The maps are the
Right.
only way I can really follow it, but then it's hard for me to work at the same time. I've got to focus in and look at these maps going through. But those are 3 cases I'd love your take on eventually if you'd come back.
Yeah, and if you give me a minute, I'll give you 3 responses.
Okay.
One, I think yes, I totally agree with you. Is that one of the things we teach is try to be interesting when you're talking about cell phone
Mhm.
records because it's not that exciting. And so I try to sound excited about it, even though I've done it hundreds of times. And I think what really makes it interesting for people is make it relatable to their own life. And for example, ladies and gentlemen, when you're doing this, you would have recorded this in your phone records, and then I would have seen this, and this is why I'm trying to explain to you as it relates to the defendant. So I think a good demonstrative, and if you want to see something like that in one of these trials, I would be able to look at how they're presented it, and I would probably be able to create a separate demonstrative for your audience of,
Oh,
okay, their demonstrative wasn't bad. What if it looked like this? What could we have seen, right? And I could probably pick that up by just watching on the screen. Second would be, yeah, I'll look into them if you want to have me back on some of those. I'd be happy to do so. But I'd like to leave your audience with something a little interesting just to think about before they leave. Is that in my world and in this world specifically of phone records or mobile device records, is that people's vehicles these days and even certain Lexuses have SIM cards in them, and those SIM cards have phone records. And one of the things that I pointed out in my analysis is that no one ever obtained Karen Reed's Lexus vehicle cellular SIM module.
interesting.
And we would have seen cell phone records from her vehicle. And I think you're going to see some of these things from cases as we move forward of what did the SIM card from the vehicle, which is that SIM card's being used to send data sessions and reports of diagnostics back to Lexus, Toyota, Ford, Mercedes. So they get to see what's happening in your car from their perspective so they can send, things out of recalls and whatnot. But I've solved a very important homicide case, quadruple homicide, with a SIM card from a vehicle.
Yeah, I mean, and that's the type of stuff where, I always assume Big Brother's watching. I assume Michael Easter is reading all of my Facebook messages and text messages on my phone, but it's like we don't even know how all this stuff works. I want my
Right.
phone to connect to my car when I go in and all my text
Right.
messages pop
Of
up and
course.
me to be able to say, call Mike Easter as I'm driving, but
Right.
that can all be tracked. And it is
Right.
the new age and how people are getting caught and how law enforcement is catching the bad guy. And I'm all for that. But, having to explain how it all works and people understanding, how
Right.
all the gadgets in their life work is really
Right.
important. So, but
I
I really
think
appreciate you coming
people.
on, especially with, so 2 things I'll tell you just that are interesting. I would love your take on the bump in the Adelson case that the feds did to try to get everybody back involved, which
Yeah.
is exactly what you were talking about
Yeah,
earlier. Like we
that's
stay there at
really,
target.
I'd love to look at that. It's
It's really
really,
cool.
it's a sensitive technique because you really got to make sure you're not re-engaging or entrapping somebody. We sort of like think of it as tickling the case. Like
Mhm.
we just get people going again. What's going on here? Let's do a bump.
Yeah.
I think I don't want to keep you. I know your story goes short. I think
Oh, you're
I was gonna mention the God, I totally forgot. I got so excited about your bump comment.
the
So
demonstratives in
yeah.
YNW Melly. That's a
Uh,
really interesting. I want your take on. Well, think about it. I'll answer a couple questions
yeah,
while you're thinking about it. Because I'm going to hang on and answer a few questions here.
yeah. Let me think about it.
Um,
Maybe I'll see something.
Yeah, yeah. Uh, what about Proctor saying he wouldn't do anything different? Yeah, that's kind of what we were talking about with the culture and from the top down, and that's not a
Maybe
surprise. And
maybe that's the problem.
exactly. Peter, you need to do a video on the deposition of the honor your oath that's going around. It's classic. I have not seen that. So if somebody wants to send that to me, I
Me
will
neither.
take a look at it. How about finding out who owned the Ford Edge seen there at the area where John O'Keefe was found that morning? If this is
That's possible. Do you want me to discuss any of that?
sure, go for it.
Well, so it goes back to the SIM module. Is we can do a tower dump from AT&T, and we would have seen all SIM cards available in that area or IMSIs, and we would also see the access point name, which would have identified it as a vehicle. And so, if that Ford Edge had a SIM card in it, we would have uncovered a Ford Edge, and we could have then traced back to its VIN and its VIN number to its registered owner.
And even if you would have thought Lucky Laughlin was not a credible witness, this would have been something pretty easy to take a look at. And again, eliminate the people in the house who have been
Right.
victimized and they say they've been intimidated. Like you could have been eliminated as a suspect pretty easily if you would have let them take a look at all the Ford Edges you had or the vehicles that you had to show
Right.
exactly where they were.
Yeah, I totally agree.
Most shocking misstep in the investigation, if you had to pick one.
I wouldn't point to an exact event, but instead a theme, which was the premature uh, categorization of her as your sole suspect and never considering any alternate theory. I think it
Mhm.
was detrimental. They never recovered from it.
Kelly said, did you have a chance to look at Karen's phone data? He's not going to answer that one. Anything that has to do with the actual client on the case he was working at, we'll stay away from that. Based on your experience, will the feds rely on Cellbrite trial findings or conduct their own when it comes to the 227 search on James' phone? What did you think about the way that the Commonwealth, I don't know, belittle is not the right, discredited the Cellbrite report and just basically said it's completely wrong?
Yeah, I mean, maybe to steal a comment from the trial, they used it as both a sword and a shield, right? I mean, they used
Exactly.
it when it benefited them and then poo-pooed it when it doesn't. Uh, it's never great when you're trying to prove beyond a reasonable doubt. Um, I definitely agree that it does make you think, right? And it goes back to Peter, like what I talked about before is why do we have conflicting times? And I think they tried to address it, but I don't think they addressed it completely how I would have done it. I would have liked to have gotten McCabe's cell site records. And so then I could have seen her data session logs and I could have said, well, she wasn't even using um, data between these times. So it's most likely that that data session occurred at 6. Or I also would have liked to have seen where was she when these things took place? Was she at home sitting in her bed? Well, maybe it's not as reasonable that she would have conducted a search for how long to die in the cold. If instead she made that search at or near 34 Fairview, it would make more contextual sense. So I think I would have liked to put it in that to give it some the search to give some context of location. Where was she when she made these search? At 227, she said what? I was looking at Hoffamak or something. I don't
Sports. Yeah.
recall of her. Yeah. Okay. Well, was she really at home when this was happening? Yes. We have her cell site records that show she's at home, right? So, and then at 6, or the next time I think it was like 6:04, 6:06. I can't remember the precise time, but where was she? We know on video cam where she was, but I would have then correlated that with the cell phone records. And again, the data analysis I think I would have done to show when was data usage occurring on her phone.
And that's the great part about all this, right? Is somebody like you can take 50 different points, line it up, and make it make sense, and really
Right.
corroborate and do the double work, as Yuri Buchanan would say. Because if you've got what she's saying, when she's saying it, and where she's saying it, that can be pretty important in putting together an
Right.
investigation. It's just like they left
Right.
parts out. Who
Yeah,
knows
why would
why?
you when he said we want to do double work, it's not called double work, it's called corroboration, where you're corroborating and validating other evidence with other evidence. I mean, they tried, it's interesting, Peter, they tried to do it on the stand and it really didn't come across well. Remember, they tried to validate when the timeline of that 3-point turn or the
Yeah.
backing using an anchor from Waze. And it's just I mean, clearly the witness they brought for that really just killed the credibility of the final assessment. You heard Brendan try to forget they didn't have to agree. Just think about what he said. That he's the only one that did these things, and I think you just can't forget that exchange and then accept his testimony. It was just they were too married together, and I just don't see how Mr. Burgess recovers from that.
Yeah. And I mean, what does the jury pick up on when it comes to that stuff? And how does it hurt the credibility of an expert witness is probably juror to juror, really.
Yeah.
But people have so many questions about like the key cycle data, the cell phone data. I've thrown some questions up there about, do you think it was interpreted correctly? Somebody said it was by the flagpole. Is that 100% accurate? And I think you mentioned you discounted a lot of it because it was either confusing, complete opposition between the experts and a battle of the expert. My dad says, all the research shows when we talk about these cases, they kind of throw it both out, maybe use their own logic. Is that how you would view it as well?
I would. And my expertise is not in interpreting key cycles. I just don't have that. And so but I did listen to it as an expert in data. And I just thought the representation of that was just really hard to follow. And I look at data all day, every day, right? And I just couldn't follow along to a point that it was really believable. And yeah, I don't want to say I was disappointed in it. I just don't think it was tested enough prior to coming of how they were going to present it.
Yeah. Peter, what a week you're having. Wow. Really enjoy your content. Please ask Easter if he plays pickleball. You ever play pickleball?
You know what's funny is I've been up here visiting in the Northwest, and I played pickleball for the first time with my daughters and my wife, and even my parents who are in their 70s.
Hey,
And
we welcome all. We welcome all.
You know what I loved? What I loved about the game was my parents, are still very athletic type people and very active, but we couldn't go play tennis. We couldn't play a game of basketball.
Exactly.
But we could play pickleball, and their reaction to that, and you're not going to sit there and smash overheads at my 78-year-old mom, but we could still enjoy it as a family. And I thought it was just what an enjoyable game, and I was surprised how competitive my mom still was at sports. She played high school basketball, and she hasn't lost a touch of competitiveness for sure.
Yeah, the second time I ever played, my buddy who I play with all the time now, his whole family grew up tennis family. His mom, similar age group, a little bit younger, and his wife pickled 11-0 me and my brother-in-law, who are two 35 to 40-year-old men who consider ourselves remotely athletic, not very athletic, but it can happen, right? Especially if you're at different levels or you had somebody that played tennis coming into it as a big, makes a big difference. So that's awesome. Let's get you on the train. If you're ever in these parts, I got a pickleball court in the backyard. We'll call you have to come this way and play. Bring the whole family.
Well, I tend to be a gear guy. I was like, I'm in running shoes, and maybe I need to go get a court shoe for this. I mean, I've only played twice, and then I noticed that my racket. I'm like, wait, there's some really nice rackets. Some of these people have. Should I have one of those rackets? Their racket sounds different than my racket does. So
definitely. The paddle makes a huge difference.
Oh yeah, I heard one guy hit the ball, and the sound. I was like, ooh. That racket sounds better than my racket sounds.
You're like, I want that sound. I want that sound. But Michael, have you ever taken one class on dog bites? I had to do it. Yeah, not his expertise. He'll stick to his expertise.
You know what I thought? Just real quick on that, I thought it was an amazing piece of testimony or representation. I think Alan or whoever did that was, how did all the shards of glass magically fit in those holes so perfectly in a parallel sequence to then make those cuts? And you saw Brennan try to make that work. He's like, you see the shards of glass flying through the air, and you hear Dr. Wolf like, yes, but they're all traveling at the same speed, right? And he's like, the arm could even be traveling at a slightly faster speed, which is why it's in front because of that. I think he called it the whiplash or something like that. And so it's just like, I thought that Brendan trying to make that fit, I think ultimately those things, trying to constantly go over it with Dr. Wolf, who was clearly just an enormously smart man, just didn't work. Math didn't work. And watching them do math on the stand, come on, I'm like, do not ask me to do math. You could give me 5 calculators. I'd be like, listen, we better get somebody that knows math. But he's like, boom. I'm like, good God, that's cool.
Yeah, but again, just like if you would have testified with them, you still have to like pick your best points. You can't be up there for 5 hours. So you have to pick your best point. I mean, they were up there for more than 5 hours, I guess, theoretically. But I'm saying in this type of case, you got to pick the best stuff because there's just so much you could potentially run through. Yasu Peter, my hubby and I love you and your dad. Can the FBI case be reopened? Yes. Your podcast with Alessi and Eddie Will you invite attorney Alan Jackson? I've talked to my people are talking to his people kind of, but I don't think he's doing interviews. I'd love to have him on. He seems amazing. I'm sure they're doing some huge things and he's busy / probably taking a break. I take no offense from him if I never get to talk to him, but he was amazing. Loved talking to him. Your interaction. What are your thoughts on Alan Jackson?
Do you want me to send him a signal message? Would that be helpful?
Yeah, I might be
I'm
able to
joking.
find him on there.
I'm joking. Just for the record, Alan and I did not communicate over Signal, but we did commute over an encrypted messaging app. And what I would have loved to have said on that stand is, Mr. Brennan, you do know that iMessages are encrypted end to end, and you do know the Android platform RCS chat is also encrypted end to end. So there's nothing nefarious about Signal. It is also encrypted. All of you sitting here watching this, you should try to use an encrypted messaging app for sure. My response to Alan is, uh, clearly remember I knew him as a prosecutor. I worked a very important homicide case with him back in 2008 as a agent. And then the next times I saw him, he was, I was going to say busting my, but giving it to me,
Yeah.
And I'll tell you what I've always found to be true of Mr. Jackson is whether he was the prosecutor or the defense attorney, he was always professional, and you can see it when you watch him. He is a true professional. He is one of the most engaging. I think he has a lot of charisma. You saw his opening and closing. It's the reason he did it. He is a very effective communicator, and as a witness against him, so to speak, as he crossed, you really got to be careful. I don't want to say battle because I don't look at it as a battle, but having a discussion with him is he's one of the few that I would consider to be as skilled at me at this interaction and more skilled. And so I sort of, when I went in, I was like, hey, I'm just playing it straight with Mr. Jackson. It's like, what do you want? Yes. No, I ain't giving you a lot of extra. I'm going to make you work for everything you get from me. I ain't over answering questions. I'm not under answering. It's just the facts and only the facts.
Yeah, and you saw that with some of the experts that were called, very different themes and strategies from the lawyers as well. So the witnesses think that way, the lawyers think that way. Do you have to be an FBI / cop to become a cell phone expert? No, we've seen some that are not. You don't have to be. Where's a good place to learn other than those avenues? I don't have the physical ability to be an FBI or cop or FBI Academy, LOL. I get school. I don't know.
Yeah, there actually are companies that offer training to private citizens. Precision Cellular, I think, is one of them. You could go to their website and take a class. I'm not sure. We got to remember a lot of these individuals do not provide training to non-law enforcement because the reality then becomes, how do you get access to the records? And you can't just say, hey, AT&T, give me so-and-so's records. You have to have a legal demand.
Right.
And so it's the wall of getting into it is because of the access to the information.
Mm-hmm. Mm-hmm. Where's all the blood from John's head wound? That was not something they really focused on. And that's one of those things where you got to kind of pick and choose what the focus of your argument is going to be and your investigation is going to be. What does the FBI investigate in a public corruption case?
Oh gosh, there could be several things. Typically, you would look at it as color of law violation or misuse of your power and authority, right? Always conspiracy. If you have a crime, you have a conspiracy, according to the FBI. You could look at extortion under color of law. You could look at traditional civil rights violations because of your race, creed, or color, like those types of things. I think in this case, we would see a misuse of power.
Mm-hmm.
I don't know if that answers your question.
He can't answer that.
Yeah, I don't think I'll be a witness in that case. No one's intended to call me about it, and I will tell you that the agents that I had assisted in this case are some of the best investigators. I want to say they're the best in the. I know Nick Blunt.
I was going to say, is he one?
Nick is an incredible agent. I was actually his instructor from the beginning to end, which would have given him that CAS certification. Nick is an extremely bright individual. I have the utmost confidence that he is going to give you guys an amazing and accurate testimony, and there's no doubt in my mind.
That's
and
awesome.
he's fair. When you see him, you'll be like, I see what Mike's saying. He's just a fair guy.
Yeah. That's awesome. Okay, here we go. I knew this was going to come eventually. What do you think about other FBI agents, Jennifer Coffindaffer, believing that the Commonwealth proved their case 100% and the reason for the not guilty verdict was jury nullification? Basically, I guess we could just do it generalized. What do you think about other agents that come out, say they think, it was jury nullification, easily proven, disagree with the jury's verdict? What do you think about,
Mhm.
those kinds of comments generally?
Yeah, I actually don't know this person. Someone's asked me about her previously, so I'm
She
familiar
comments on
with
like court TV and stuff. She's a former
Mhm.
FBI agent. She goes on, some shows and talks about a bunch of different cases, not just this one.
Mhm. Yeah, whether she's former FBI or someone else, I'd always go back to what is your background, training, and experience to offer such an opinion. If it's just simply I was an FBI agent for 3 days or 3 years and I never took a case to trial, I might weigh your opinion slightly less. If she has a lot of experience, and maybe we should listen to what she's saying, maybe see her perspective. I think your channel, or you, at least you, have always done somewhat of a fair assessment. I think we can all see where you might lean, Peter. But I think ultimately, you have to see the other side. Why do they
Yeah.
see it this way? Let's understand, why is it this their perspective? And I've always told, I tell my daughters, is when you get out in the world, I have college age kids, is that your life, how you perceive life and want to do your life will be challenged by people,
Oh
and
yeah.
they're going to challenge your ideals and your faith and your belief, and it'll either sway you or it'll make you steadfast in your belief in your faith, and those moments will define you. So my point to that is, if we listen to her opinion and it's different than ours, maybe we should understand why she's come to that conclusion and why other people would, and maybe we can reinforce why we believe that she's wrong, or maybe we see parts of her opinion to be correct.
Yeah, and I think it's totally fine to disagree with people. And I think you have to understand that everybody's experience is different. Not every FBI agent's the same. Not every lawyer is the same. And
Right.
if you disagree with it and you don't like it, you can disagree with it and you don't like it. And
Yeah.
that's okay too.
Yeah,
Um,
she may have an entirely valid opinion. I'm not familiar enough with it to say, to necessarily agree or poke holes in it. But I would just say that, like
you
you,
would
Peter.
disagree with the way she sees this case. I've seen some of her tweets and stuff. You would
Okay.
disagree with the way that she sees this case, which it is what it is, and it's like sometimes I
Yeah.
don't give a lot of thought to some of the things people say online. And sometimes that feels like the best.
I think my final opinion is I believe that the jury came to the accurate conclusion based on the presentation of the evidence and how I would have seen it.
Mhm. Why can't the attorneys talk about the garage pictures now? It seems like they're still releasing these pictures and videos from the PI. It's their decision, right? They're gonna comment
Yeah.
on what they're gonna comment on, and that's totally up to them. Coffin Dapper wasn't a firearms instructor. I don't know her background, so I can't really comment on it from my perspective. Why did they never ask Google when the search was made?
It's a good question. I brought that up in another conversation. If that was critical to the timeline and critical to disproving that she was a suspect, I would have done it. I think, and to try to be as fair as possible, is that I could see in the moment they didn't really know about that search until a little bit later, right? I mean, I don't, if I remember correctly, it wasn't like they knew that contemporaneous with her interview. I think it might have come out a little bit later. And in fact, I feel like, if my recollection is correct, is that the defense is the one that brought it out into the light prior to the first trial.
Mhm. Yeah, no, it definitely was. Tickle the case, please. Zachariah Anderson, Wisconsin. Nobody, no evidence. Very similar to Karen's case. I mean, that alone seems different than Karen's case if there's no body. But some people have mentioned this before.
Sure.
I have never seen anything on it. I don't know if you have seen anything on that or
No,
Barry Morphew. Have you heard about Barry Morphew in Colorado?
no.
So he got charges dropped because prosecutorial misconduct, and he just got indicted again in his wife's death. It's a pretty interesting case. I mean, you got to pick and choose because they'll ask you about 1,000 cases. You got to kind of pick and choose
What's
which ones
funny
you
is
really try to
I'm
dig in
horrible
on.
with names, but like there's oftentimes, like, if you give me the circumstances and what happened, I'm like, oh yeah, yeah.
Oh
I
yeah,
I did that
the
case. Like, some
facts.
people have been like, "Hey, have you heard of this case?" And I'm like, I had somebody call me, a defense attorney. He's like, "Hey, I want you to look at this case." And he starts describing it, and I'm like, "Was the crime scene at a Ralph's?" He's like, "Yes." I'm like, "Okay,
Yeah,
stop. So you
I
should
get
stop
it.
talking to me."
Yes, yes, exactly. Do you think the Fed said it was complete because Hank kept making new TUI requests in the couple months before they announced it? I don't think that had any effect on what the Feds decided to do.
Yeah, I think
And
you really your audience. I was going to say the jury. The audience really needs to remember that the FBI is not easily or the DOJ is not easily persuaded.
they decide what they're going to turn over in TUI. And if they make a mistake, they'll explain why they did later.
Yeah, I mean, the TUI request. I used to have to do this all the time as a state witness. They'd have to do the TUI or scope and relevancy letter to the DOJ
Yeah.
and get approval for me to appear. That you know what, they just, it's an administrative thing, but they're happy to just sort of We'll get to that later. If we don't want you to testify, we'll respond. When's your trial? It ends on the 15th. Well, we got back to you on the 16th. We apologize for the delay.
And there's nothing you can do. Like the point is, there's
No.
nothing you can do. So we talked about Dever earlier. If you want to back it up and roll back the tape, and he gave his kind of comments on how that went. Ask about the dang socks, please. Where are they? What happened to them? And why can any of the attorneys talk about them? It is making us crazy. I don't have you. Did you put any thought into that?
No, I didn't.
Yeah, me neither. It really is just. There's just so much. Like there's just so much. And
it goes back to your point of what I always think of: what does the evidence tend to prove, and what does it disprove? And if the socks were really that important, I guarantee the Karen Reed team would have brought them up.
Yeah. So this was an interesting question with Judge Cannoni's family having past connections with the McCabe's and Alberts. Why was it never brought up to have her removed? I don't know all these connections. A lot of people said it. I think if there was a legitimate reason for it to be removed, the lawyers would have brought it up. What did you think about all the connections that the cops and the investigators had to all these people involved? Like that's pretty wild, right?
Yeah, it's interesting. I grew up in a small town, and I was a law enforcement officer in that small town. Went to college there, and actually came back as an FBI agent for a short period there. And I've had instances where I remember one specific, and I just give you an example. As I was working, we were doing an undercover case, and I had undercovers in a building that my sister walked into. And so I remember I'm surveilling the building, and we have something going on in this building with the occupants, and my sister goes into that place, and I'm like, of all the things, this is just how small towns can work.
Exactly.
It is what it is. Does that mean that I have a problem? No, because I texted my sister, would you please leave that building? And she goes, oh, okay. It's like she knows what I do for a living, and I just put in the report. On such date, I observed my sister arrive and enter the building. And the abundance of caution, I texted my sister. I put a copy of the text in there. I asked her to leave the facility, and she did. I mean, it's sort of one of those things, Peter. Like, if things happen, you know what makes it look bad is when you hide things that aren't bad. Why are you hiding something if it's not bad? Just explain it. Just write it down. But you know what? It became a joke. They're like, so your sister showed up in the undercover case.
Yeah.
Yes, but not by design.
Yeah, exactly. I mean, that's just how I tell the story all the time about we were in this small jurisdiction trying a case, and the judge was like, okay, prosecutor, I have to disclose my dad was the chief assistant of the criminal division in Middle District of Florida. And he's like, I worked for Mr. Tragos as a federal prosecutor. It was a really small jurisdiction. He's like, so if you want me to recuse myself, I will. I'm happy to. Just to let you know, the only other judge in our county also worked at the same U.S. Attorney's Office under Mr. Tragos as well. So if we switch, it is what it is. It's 6 and 1/2 dozen in the other. What's your theory as to why no data of phone movement later in the night from the house to the flagpole if they were planting it under John? Doesn't that say the phone was there and never moved? So this is kind of on the other side of how did the phone
these questions are these questions are hard because it requires me to speculate that the phone was moved, right? And requires me to speculate that they moved it and planted it. I try not to engage in the speculation of that because the data is the data, and if it doesn't show anything, then I can't. I always tell people I get this question a lot. Is it on the stand? It's hard to offer an opinion of something what happened when nothing happened.
Right.
So if there's no data, I can't tell you that something did or did not happen. Is it possible? Sure, there's possibilities, but it's I always kind of go back to probable. It's not probable.
And you're on this side. You don't have to prove it.
Yeah, that's I thought they did a good job. It's not, and I think you covered some of these things. And I even get these questions. Why didn't why didn't Alan and them prove this happened? I'm like, well, because it's not his job to prove the case. That's the Commonwealth's problem.
Did you ever work with Sheriff Baca out in Los Angeles 10 years ago?
The case and I just have no comment about that.
Okay. Should Brian Higgins have been fired after using FBI equipment to extract cell phone data? He probably has no opinion on that either.
Well, I'll just nod.
Okay. All right, Mike, that's it. We got to run here, guys. Thanks for hanging a little extra with us. This was fun. I hope we do it again in the future on one of those cases or maybe something you become interested in that we can talk about. Thank you, everybody, for joining in with us. Make sure you guys all hit that like button and subscribe, and let me know what you thought about Mike in the comments. We'll go through, read them later. Nice stuff only. That's all we got. Till next time, we're out of here.
Thanks, Peter.
Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos.